Street.
Thank you very much, Mr. Chair. I rise to speak to this part two of the Victims of Crime Reform Bill because this is the bit that tries to align the Victims' Rights Act with the Children, Young Persons and Their Families Act, and so this is the part of the bill which tries to capture the answers to the problem, which was that victims' rights in the adult criminal jurisdiction were different from those applied in the youth justice jurisdiction. And that is, or was, a problem, and this part is the remedy. We support this part, Mr. Chairman, as we have supported the other part, part one of the bill as well. But there are a couple of things that I wanted to draw attention to in particular. First, it's been noted, and I don't wish to labour the point unduly, but given that this was reported back 2 years ago, those of us who have found ourselves on the, or I have found myself on the Justice and Electoral Select Committee for only a comparatively short time, since the end of last year, have not been privy to the submissions because the report was presented on the 27th of June 2012. And that means that going back and trying to capture the sense of what was the top-of-mind concerns for the submitters has been quite difficult. But I am going to refer to the regulatory impact statement in some detail. Mr. Chairman, in the regulatory impact statement on page 14, it said that the current situation is that the Victims' Rights Act gives little guidance as to how its various provisions apply to the processes in the youth courts to deal with offending by children and young persons. And so there was this disjunction, there was this gap between the treatment of victims in the adult criminal jurisdiction and the treatment of victims of crimes committed by youth offenders and children, so children and young persons. So as a result of that disjunction, there was some confusion about the application of the Victims' Rights Act to the particular circumstances that apply in the youth justice jurisdiction. And this is a good answer to that question. This is a reasonable remedy to that problem, because what it does is essentially means that victims should have the right to attend youth court hearings. It says that victims of children and young people, that is, victims of crimes committed by children and young people, should also be able to provide a victim impact statement to the judge, as is provided for in the criminal jurisdictions of the high and district courts. And amendments are made to clarify the application of the Victims' Rights Act in the youth jurisdiction. And this is particularly found at Clause 39 in Part 2, Mr. Chair, where Schedule 1 is amended. And it's amended by inserting the relevant bits of the Victims' Rights Act tailored for this circumstance. So, for example, it says that the definition of a victim also includes a person who, through or by means of an offence committed by a child or young person, suffers any form of emotional harm. And it goes on simply to align those provisions in the Victims' Rights Act, which this bill also amends because it is an omnibus bill, aligns those provisions with the, Mr Chairman?
Honourable Marion Street.
Thank you, Mr Chairman. With the Children, Young Persons and Their Families Act. People have talked previously in this debate, Mr Chairman, about the relevance and the purpose and the usefulness of children being able to demonstrate through pictures or drawings or some other mode of communication the impact of a crime upon themselves, or witnessing a crime and the impact of that on themselves. This does allow those voices to be heard in the children and young persons jurisdiction, and that has got to be an improvement. Mr Chairman, I think that this particular bit, we're aware that the bill itself amends 4 pieces of legislation: the Victims' Rights Act, the Children, Young Persons and Their Families Act, the Parole Act and the Sentencing Act. And by making sure we have some commonality between those 4 amended pieces of legislation, we really are moving towards something that is consistent in its approach, recognises the impact on victims, recognises the rights of victims, whatever their age, in this case, whether they, in the case of being victims of offences committed by children or young people, allows them the right to be heard and to have their voice heard in proceedings in the children's and young persons' jurisdiction. Thank you, Mr Chairman.
We have a couple of SOPs, or we have one SOP that has 2 parts to it. So put the Minister's amendments to Part 2 set out on SOP number 424 and the Minister's typescript amendment to clauses 33 and 39, replacing Section 2A and Section 2B. The question is that the Minister's amendments be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question now is that Part 2, as amended, stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question now is that Part 3 stand part. Honourable Phil Goff.
Mr Chairman, this is a very straightforward part, so I only want to take a rather brief call on it. It's